Are we ready?
Yes.
Okay, so
Well, not yet. I'll tell you. Here we go. Okay. All right, we're going to reconvene the meeting at 11:18.
okay,
Member Forbes had to leave. He had a prior engagement, I believe.
okay.
Yes. Okay.
So we finished up the ordinance dealing with Chapter 4 changes,
Yes.
and we're now doing another ordinance. Now, technically, this could be a land use ordinance. It might not be. It's not going to be part of the Land Development Code. But I've had this situation before in an abundance of caution where I like the LPA to do a review of something that relates to land use because I once had a judge determine something was land use. And it's interesting, how they all go over. So I just like to get it done. Anyway, this is the Property Maintenance Code, and we've had it for quite a while. I think you guys have seen it in the past. This is the one that deals with a lot of just making sure residential properties keep it nice and real for the rest of their neighbors. This section, we're doing two changes, but before we do the change, one thing, and similar to the point about Land Development Code using the term director, we use the term landowner, but in this case, a landowner could be a tenant. A landowner, sometimes the landowner might be hundreds of miles away, or thousands of miles away, or in another country. So making it clear it was anyone who really has control of that property.
Okay.
So,
I noticed you're turning a page there. Can we stay on that first page?
Oh.
We need to clean up the bottom, not the last line, but the second last, is whereas City Council wants to regulate pods for a limited time period on residential property. I think you could just put a period there because
Okay.
it gets confusing.
okay, thanks. Got it.
Okay.
And we also have a typo. I was pointed out that I spelled property wrong, and that's one problem about caps. The spell check doesn't always pick up. So the title block will also be corrected. Thank you, Jackie. So we got the definition landowner, just to make it.
No, we didn't quite.
Oh.
Need a little clarification. Under Section 2, the definition landowner, you're saying that any notification that you give to the person occupying that property is the same as giving it to the property owner. I have a little problem with that.
Well, and again, notification, no, it's not a matter of service. It's a matter of, now, if we give, say, a citation to somebody, we're not necessarily giving it to the underlying fee owner. We may give it to the tenant. So these are not the ones that you typically get a lien on the property. Usually when there's a violation here, it goes into citation.
Mm-hmm.
So
Lawn mowing, for example. It always comes to me in a registered letter, sooner or later. I think they send you a letter and then they send you a
shouldn't be
registered
having those
letter.
on your property.
Yeah, I got an empty lot that I get
Okay.
all the time. And so, but the property next door, adjoining to it, they could leave a notification there?
No. Okay, let's go through. Well, first of all, lot mowing is a different ordinance, and that has different.
Okay, but let's
but-
just
but
take
let's say
anything.
Let's say your fence is in disrepair.
Because I don't want a renter to become a representative
Right.
of me.
And they're not.
All right.
Okay.
Doesn't it cover
It's-
that?
It's basically that we can ticket, instead of ticketing you, something that the renter should be taking care of, we can ticket the renter. So an example might be getting a pod, okay? You decide your tenant doesn't come to you. You don't know your tenant is doing this. We're not requiring the tenant to come to you. They need to put a pod in so that they have some room while they are redecorating the house. They're not getting a building permit because we address that differently. They're just, let's say they need to move their furniture out because they're wanting to fix it up. Or they just have they have more stuff than they have rented, so they really want the pod, not for that temporary purpose, because that's what we have under the code. They really want it because they have a lot of other stuff. Maybe a boyfriend moved down, to move in there, and he brought his stuff, or another family member. And they just don't have the storage space, and they don't want to rent a storage thing. They just want to use put that pod in that right location. We can, they put the pod, they're not moving that stuff to a storage facility. They really want to just use it as a permanent location for their excess stuff, their belongings. We don't have to go to the owner. We can cite the tenant who's actually creating the violation.
I understand what you're saying, exactly. But if you cite the tenant, for example, ultimately the landowner is going to be the person that is going to be responsible or pay the fine or whatever the case may be.
No, only if there is a lien placed on the property. So if there's a lien placed on the property, now remember, code enforcement, if you look at chapter 162, there is no requirement that that the violator must be the property owner. We like to do it that way because by doing it that way, the property owner doesn't want to lien on the property, so they're more likely to fix it or get it fixed. But we want to make it clear we have the option to do above and beyond that. We can go to the tenant, because let's say you live in Germany, you're renting your property to some nice people, and they really have all the control of the property. You haven't been down into the United States for maybe 5 or 6 years. And I have an actual house in my neighborhood like this. Those nice people who are the renters, who then sub-rented, 'cause it's actually true, they're the ones really responsible to take care of. Now, we would not put a lien on the property by sending it to them. We would have to go through the proper notice or constructive notice. But we could cite them because they really have the actual control or possession of that property.
And they could be fined.
Correct.
But that would not extend to the owner of the property?
Only if we cite the owner. If we cite the owner, we have to provide service to the owner. And by service, it's either actual service or we would do constructive service, which is usually posting out here at City Hall. It used to be by publication in newspaper, I believe now, and don't quote me on this one.
It involves a registered letter.
Right, but I'll give an example. I have a neighbor who's dead. He's not going to get that registered letter.
Probably not.
I hope, yeah, we're not that good, in service. So we post it out to the world, and that's allowed in the statute to do so. So that if there is now I would hope I would tell his daughter because I know his daughter, but, there would be something like that. And we've had those situations happen where something bad happened and, we know that the owners you can't reach and actually worked with the neighbors to take care of the violation.
In that same case where you have an owner in Germany, someplace like that, in this tenant who's been in for a few years, a good tenant as far as the landlord is concerned, and you cite this person several times and they're not paying, and you say, well, what's your recourse at that point? The owner probably doesn't want to lose them as a tenant, but yet, you're citing this person for...
We would probably go after the actual owner of the property. We would not use the tenant, escape valve.
Would that be stated in here that you're going to receive so many notices and so forth? Are you planning to do that?
No, it does not, but I think that's a discretionary. I think if we're going to go after the owner, we
By
want to
code
put a lien
enforcement?
on the property, we're going to go after the owner,
Okay.
who has the real property right.
So you might do that simultaneously.
Right. What I did is I called it loosey-goosey. And if you look at Chapter 162, it's also very loosey-goosey. It refers to a violator. The violator does not have to be the property owner. Now, because the property owner is the one with the purse strings, we usually go after the property owner. But, we can go after others, but good luck trying to get money. You're right, getting the money.
The reason I mention that is because as a property owner, absentee, I may say, well, if I had known you'd gotten 3 violations, I would have paid it because I like you as a tenant.
Sure.
So somewhere in there, the owner has to be given a chance to either pay or not pay.
Right. Understand that if you're writing a citation and the person ignores it, you sometimes get a bench warrant. And that gets to be a problematic. I know in Cape Coral a few years back, you had some people put in jail for water violations. And by water violations, they were putting sprinklers on the wrong day. you know, which seems to be thrown in jail for, is a little bit of a problem. I actually know a person, but I'm not allowed to say it because I know I'll get in trouble, who actually had a dog roaming at large and got picked up, and unfortunately it became what I consider a cool hand Luke moment for that person, because matters got worse and worse. I'll give names later if you want, but I don't think I'm allowed to say it on television as to who it happened to. And I know John's giggling because John and Jackie and Debbie all know who it is. But it was so I mean, we try,
Situation.
the court system, we are working with the court system not to have that happen as much.
Okay.
But, there are outstanding things that are out there, and do recommend to people to check their name in the Lee County Clerk to see if there is any outstanding warrants for, civil citations like this, because it can be problematic, and speeding tickets. Because if you're supposed to appear and you don't appear, you can later find out it's very problematic.
On that same page, the top whereas, that needs to be cleaned up just like the front page,
Okay,
where it says to regulate them for a limited time period.
Okay.
For a reasonable time period, so, gotta pick one. Rex, you got something else there? No? Okay.
oh, good, I appreciate
No,
it.
I'm really not comfortable with this new insertion, but we'll go with it.
Okay, and understand that insertion is kind of the practice, so it just made it more clear so that it would, it's just a cleanup. It's not really a new substantive right.
Well, one time I had occasion to have a sheriff accompany me, or a sheriff needed to go into one of the properties, and they would not go in on the word of the tenant to see if a person was all right in there. They would not use the word of the tenant. They had to have me there physically to do that, and so there's a kind of a strong relationship there somehow or another with the rights of the owner, and I don't want to get in any situation where the landowner is his responsibilities are somehow shifted off onto a tenant who might not have the same motive as the
Sure.
property owner.
And nor does the city want to get dragged in a landlord-tenant, fight.
You would have to infer that, because this says specifically that pursuant to this ordinance to cite for violations. In your case, might be something totally different there, but here it would be-
Right. And the other thing is, this ordinance applies to exterior of the property. It really doesn't apply to anything interior, so I'm not really worried about Fourth Amendment issues, which you typically have in the landlord-tenant and what we have in the
Parking,
IPMC.
parking disabled car in the front yard or something like that
Yeah,
would
yeah.
be where this would apply.
Exactly. If you want a situation, oh gosh, I remember that conversation with the LPA, where say there is a unlawful vehicle, because I remember this group wanted you should always have the right to have one disabled vehicle language. That was a long time ago. But let's,
It's yard art.
I'm going to still remember some of these bad things. But the disabled, you have a right to have one disabled or derelict vessel on your property, rule that we had for a little bit. But, if it belongs to the tenant, cite the tenant. Don't, instead of going after the property owner himself. Because it just, the property owner's far away. He doesn't care, and it's, the dominion of that. Okay. So hopefully that's enough on this page.
I have an idle question here. What the heck is a derelict
Derelict vessel?
Any vessel that's out of the water, it's blocked up in your backyard, it's got to be a derelict.
Not necessarily, if it's operable.
Can't-
Derelict vessel meets a certain statutory definition in 327.
Gotta
in
have a
Florida
lot of
Statute,
missing
Chapter
parts.
327. Yeah, if you put it in the
Propulsion
water
would-
and it goes to the
propulsion would be
ground,
one thing.
it's derelict vessel. If it is floatable and up in the air, you're probably okay. Yeah.
see where
Speaking of
they're
which, I
at.
probably have one in
Yeah,
my yard.
exactly.
Okay. Pods.
Oh, yes.
This is one that City Council asked us to take a look at, and again, it falls within these type of canisters or things on property. Council recognized that there is some benefit to having them on the property for short term, but, you know, again, because it is irritating to the adjoining property owner, having it for a very limited time frame. So it's 14 days. Now, this does not apply if somebody has let's say they have a remodeling permit or a development order and it's a construction site. What we're talking about is residential property where people are living there, and it's not, you know, it's not the inconvenience of your neighbors doing remodeling, so therefore you have the pleasure of the pod in the yard for an extended period. It is extended, it could be a couple years. Those are okay. This is where they put it in because they just don't want to buy a storage unit.
Okay, my question is on that, you've got a maximum of 14 days. What's the minimum lease period on a pods?
And that was asked last night at City Council. My answer was, I don't know, and it's going to continue to be, I don't know. I think Chris is looking that up. But it's not the city's business to get involved in the lease issues.
Well, maybe not, but
The way I understand these, and I'm not going to say that I'm an expert or have reviewed contracts for pods or any of their competitors. The way I understand it is you have the ability to have that storage structure placed in your property. Once you're finished with it on your property, it can be stored in one of that company's facilities.
correct.
So the term may be 30 days, maybe 15 days, I don't know. But whatever that term is does not necessarily have to be consistent with what's in the ordinance, because if that term is longer, you would have the ability to have that taken away from your property and stored somewhere else.
Ask Brenda how long.
And I think all of that, though, is with the mindset of to maintain property maintenance code. In other words, all this is under that umbrella of the goal of within your neighborhood, we have some cleanliness, order, all that kind of stuff.
Yeah. Go ahead.
So that's why you're saying those two are separate, because one is accomplishing one thing, one is accomplishing the other.
Yes, sir.
Meaning the code is set up for everybody in the neighborhood, whereas your contract is only with you and the company.
Yes, sir. And regardless of what it is today, their financial model may change, and those contracts may be different in 6 months from now. So I understand that in an ideal world, they would be consistent. But for this to accomplish its goal, it does not have to be consistent.
But you give them you can extend it to 30 days.
Yes, sir.
So there's an out.
There is some flexibility there, and code enforcement does apply common sense. So I don't look at a day or two as changing the axis of the earth, but
Well,
at
John,
least it gives you regulation.
When you get your remodel permit in a residential area, I don't think you have to have a porta potty now if it's a remodel, but you have to have a dumpster before you do anything there. And so you've got this big ugly dumpster on site, and and if you wanted to store materials on site, instead of putting it in the garage, you could put it in a lock-up iPod. The dumpster, there's no really limit on how long it can be there.
Yes, sir. The dumpster is tied to the building permit.
Yes. So the dumpster technically could be there 6 months.
In some cases, they are.
And I'm having a little trouble to saying it's okay to have this big ugly dumpster sitting in the front yard for 6 months or whatever the case may be, where we're getting restrictive on a usable, or we're getting very technical on a needed facility.
I'm not going to make the argument that a dumpster is more attractive than a pod. What I can say is that the dumpster is necessary for the length of the building permit.
I understand.
Necessary evil. The pod or storage container, or whatever you want to call it, or whatever brand name it is necessary to move something that needs to be stored from inside of the house into that structure. It is not necessary that it stay there once that material is inside the storage. So if you're looking at it's very consistent in terms of necessity. you only keep either a dumpster or a storage container on your property as long as necessary to accomplish its goal. The dumpster for waste associated with the building permit, and the storage container associated with moving material from inside of the house into that container. Once that material is inside the container, it's no longer necessary that it's stored at that residence. It can be brought back to that storage facility the company maintains.
At a future time. I understand that.
And it
But
can be brought back.
when we got a house and do 100% remodel on the thing, the first thing that goes in the garage is the appliances that we're going to save, the washer and dryer, refrigerator, stove, if they're going to be a reused thing. The cabinets and all that stuff goes in the dumpster. So when I first saw these iPods, I thought that's really neat, is we could now store all that stuff in an iPod for 6 months and use the garage to store the plasterboard and all the heavy stuff that comes in that's got to be out of the rain. And so I have a little difficulty in putting a restriction if they're actually in the true remodel process. I think it's a necessary item.
Well, if you would like, I think we can probably make something where when it's used in association with a building permit, the
It's
length of
already like that.
time.
Yeah,
is it like that?
I thought Audrey said that.
Yeah,
So,
it's already set up that this is, let me find where it is.
It ought to be able to stay there as long as the dumpster stays there. Because if you're actively remodeling a structure, you have all kinds of trades there: the electrical, the plumber, and the plastering, and the electrician, and all that stuff, who use the garage as a storage facility, and so you can't have stuff in there. So I think if you're going to have a dumpster on site
Here we go.
during remodeling, it's reasonable in my meager little mind to say, why couldn't we have the pod there for the
And
same?
you're right, and because what it says is the pod unit has the 14-day restriction with exception to an active building permit where the pods unit may stay on the property until the permit expires.
Good.
Or a certificate of occupancy
Okay.
is issued, whichever
do it.
occurs earlier in accordance with LDC 4-3044.
Okay.
So, no, we
Satisfies.
recognize that.
Good, we've got that solved. Thank you. I feel better already.
Okay, yeah. Now I'm gonna make it worse. Under 5, the last item. First of all, are the pods that big an issue? I mean, it seems like we've gone after them with a
Numbers.
double-barrel shotgun here.
It-
I'm just wondering if it's that,
Can I take the 5th?
no. Because I don't know, it seems like they're in a direct line of fire here. And the last line there just it sounds kind of Gestapo-ish to me. Says, upon reasonable notice to the landowner, the city of Bonita Springs may inspect the contents of any pods unit at any reasonable time. Yeah, I'm not real comfortable with that.
Yeah, I understand. I think the thing is making sure that, first of all, a pod is different than a house. It's different than a lot of private, I mean, what is your expectation of privacy in a storage unit? Again, I keep thinking of Hannibal Lecter,
Yeah.
type
Well, I guess
moments
you
of what
could,
you can
but-
use a store. And storage facilities have those problems. And the nice thing about storage facilities is there's a landlord there who makes sure the Hannibal Lecter story doesn't come out, theoretically at least. Those days are gone.
That just reads a little intense to me.
It is intense, but it's mainly for the purposes of protecting the public, because if you're storing flammable, let's
Do you
say,
think legally that would stand up?
If that's
far
in
as
my
the search
driveway,
and
they better
seizure?
bring help.
Yeah. I think it's pretty
well,
questionable
it
whether
says
or not
upon
legally.
reasonable notice. I mean, if the property owner says you can't go in, we will get an administrative search warrant. It won't be our first time. It won't be our last time. We've had to do that with rental. Now, that's when it's human occupation areas. Human occupation, we do need to get an administrative search warrant.
Right.
But this is not, theoretically, this should not be a human occupation area.
Can't be
Actually,
living
a
in
TED
it.
shed would qualify.
That should not be a human occupation area, too.
I know, but we've had them in the past where we've actually
Yes.
had people living in TED sheds. And so I look at this, a person could, I mean, we've had people living in storage facilities here in Bonita before, and people could actually be residing in them in a
Yep.
pod.
But the definition here says as a temporary storage unit.
Yeah,
So
I understand what it
if
says.
you're doing those things, you've changed the definition of that.
We've also
What
had
if it was
people,
being used as a meth lab, for example? I mean, which
which
But you
is
can only
very
do it
explosive.
temporarily.
Gosh darn what people like to store. But, and you're right. I mean, the thing is that, for example, we can, human occupancy, and this should not be human occupancy, but in the past, people in Bonita Springs has had human occupancy in places that should not have human occupancy.
I would just like to see that softened up a little
I
bit.
think just the
That's a
threat
little- that's
of
harsh.
it, Don, is, just the threat of it is enough to control the use of it.
Okay. That's
Could
just
be.
my personal.
And I agree with you. It's-
I'll take a look at it and we'll try to figure out some good language. I mean, I can do an administrative search warrant.
You could do things
Or
like
a
that, yeah,
consent.
if it's warranted, yeah.
Yeah, okay.
But we did have reasonable notice so they could clean it up before we went in and checked, so they could remove all the people.
Before you make any of those aggressive moves in the whole business, you gotta have some reason for doing it.
Yes. I mean, generally, there'll be a neighbor complaining. Code enforcement doesn't go out of their way to be.
And that's
Now, we
another
do
thing.
go out of the way for rental ordinance. We do inspect properties, and we've had tenants. I will tell you, the law is very clear. If we go in and do an inspection, and we see things that maybe are a violation of state law, but aren't what our purposes for, say, property maintenance code, the code enforcement officers have a blind eye. So people may have some plants and shrubbery that they're growing inside the house. That is, our code enforcement officers cannot tell the sheriff's office if they happen to see that, because otherwise it would fall within the fruit of the poisonous tree, as far as, you know, an illegal search. So when our guys are going in, they go in for very specific, so they would be going specifically towards the storage material, not necessarily, you know, if they saw people having some illegal substance. Do we have illegal in
Okay.
there? You know, or other illegal or hazardous material. I guess, yes, they could on that one. So that might be one that we put in an administrative warrant. The next change in this, was something that code enforcement reminded me, and that goes on page 8 and 9. And that's just is trailers, because a lot of times I guess they're having problems with trailers being parked on abandoned lots. So that was added. And then I believe the next, and then we have landowner or person, several times changed. I'm not going to go through that. The next big change is to section 12, which is outdoor single and two-family residential lighting standards. This ordinance did become a dark sky ordinance several years ago, so this is a very strict. What happened is, Development Standards Ordinance always had lighting standards, but we didn't have lighting standards for your single-family residential. So we put those in several years ago, and that's, I remember City Council looking at it very closely, and Councilman McCourt had snook lights added in, because very clear, you know, people should be able to have snook lights. You know, everyone has a right to fish. So we have that in there, and some other language, and I think Christmas lights have some exceptions in there also, or LEDs, and depending on which ones. There's a new addition, and it doesn't apply to the property owner so much as FP&L. And there is a state statute, it's in Florida Statute, Chapter 768, okay, I cited it here, 1382. And what happened is, a few years ago, we ran into problems where cities would want things to be darker. Well, if you turn off a light, it can be problematic, because people have the safety, that, I know I'm supposed to go through this, people have the safety desire that they want to be protected. And they said, well, if you turn off the lights, you have to follow all these confines. So we are restricting the new lights on street lights. And this is for either if the city puts it out, or if it's a utility, most notably FP&L, when they install it, they have to make sure that the light only goes to the people who requested it to be installed and doesn't spill out onto their neighbors, you know, where somebody will take their 22 and shoot it because it drives them nuts at night. As well as going up into the night glow and affecting your ability to see comets and stuff. Yeah. Guess who has a light in her eye? And that's it.
Okay.
And you will see these, both ordinances again. I'll make these changes.
Before we say that's it, real quick, when you're talking about lighting, you've added, under item 3 on page 14, we've added a street light thing, and the thing that comes to my mind as I read this, the best thing that Florida Department of Light has is their monthly rental security lights, which they furnish the whole thing.
That's
and
exactly what we're talking about.
Okay. How does that fit in here exactly?
You purchase that light, FP&L, when they install it, needs to make sure it's shielded so you have security on your property. But if your neighbor does not want security, it's shielded so that neighbor doesn't get it. And if your neighbor enjoys looking at the night glow, at the night sky, they're not going to have a problem seeing things in the night sky because this light is now glaring into the night sky.
That would be the last part of it. I think that covers it. So it's got to be shielded.
Yeah.
Right, this is
I'll
just
have
an
to assure that.
anti-glare. You can
Yeah.
still put a security, but that security is going to be for your property. Does not necessarily mean you're gonna have security for your entire
Now,
neighborhood.
here we're just talking about residential.
All of it, huh?
All of it.
No.
All of it.
All of it, commercial and residential.
And this is targeted not at the property owner or landowner, this is targeted at FP&L, because FP&L says,
Yes.
hey, we'll do this if you have an ordinance.
Yeah.
So
They're a
we-
wonderful thing. The only problem you have with them is it has to be on a pole that they own.
Right.
So you're married. Where that
Yeah.
light's going to be is where the closest pole is that they own, and so you don't have a flexibility of putting it just exactly any place that you want to put it. So you've got to.
Maybe something to be written to address that.
Well, this is something I think if we start going down this path, you're going to wind up with a whole lot of regulation for a very small area. No one is preventing you or any other commercial property owner from putting in outdoor lighting. This simply looks at that type of lighting that's supplied by FPL and is located on the power pole. If that light is not going to be adequate, or if that pole is not in the proper location, you can still light your parking lot or outdoor area. It just needs to be done by you under a separate plan. So I just give you a little word of warning before we start looking at
See what you
different
mean.
scenarios.
So you're saying that FP&L can only provide that to you under that circumstance where you might not be able to get it.
It might not be the best circumstance for you. That's exactly right. You might be better served by putting in your own lighting at different locations on the site.
Leaving them in the power business.
Yes, sir.
It's a wonderful program that they have, and more people should know
Yes,
about
sir.
it because it does add a very good level of security, and it's, I think, $24 a month or something, and you don't have to mess with changing the lights and getting a 20-foot ladder and changing the time clock when the time changes and all that. So it's a great deal, and I think it ought to be explored more. But yet it has some limitations.
There's limitations on the location of where it can go, and there has been concerns as to its consistency with the dark skies ordinance. We're addressing one of those with the glare within this ordinance, but the location is something that's going to be more of an FPL question.
Are we supposed to do something with this?
This was our first look at this, so it's just, we don't need to make no motions need to be made other than the comments.
I think
That have
we've
come.
taken your direction, and
Okay.
we will incorporate that into a revised draft. You'll see next month.
Okay. So the next item, I believe, is status update on our favorite subject.
Yes. And let me go through that real quick. And At this point, I have sent to Special Counsel Beverly Grady a look at the operational ordinance. We do have almost Chapter 4 completed, courtesy of Alexis Crespo and Jackie. We're waiting for the use tables so I can plug it in and then modify the title block, and then I'll send that to Mrs. Grady. And then Mrs. Grady, just so you're aware of it, is also looking at Ms. Montgomery's equitable estoppel arguments.
Okay. And there were some excellent comments made at the beginning of the meeting on that.
Yes, and those will be looked into.
Okay.
Now, this that we got via email, right here, the 18 pages, that is what, that is the current status of this right now.
Yeah, I might have changed. I think one point I might have now, therefore, the City of Bonita Springs ordained, and I had to change it per our charter to the City of Bonita Springs ordained. So I might have made minor changes that don't apply to it. I mean, it's the most current draft. The next draft that I send out will have changes like that I've already plugged into there.
Okay, we are ready to make our notations on this 18 pages.
I think that's wise. You might want to wait till Mrs. Grady comes back and talks to you as far as any legal questions, or you might want to do this, because what I'd like to do, once I can send her both of these documents, is then have her come here. You got my letter too, and you see my concerns. I might not have looked at right to travel issues correctly. I might not looked at other issues. I mean, there are so many different, I can't tell you how many hours I pulled up different statutes on different subject matters, Clean Indoor Act, everything on drug, controlled substances, how who's allowed to administer them. So, I mean, hopefully she might give some good insight, and then that might be the draft you work with. But you could start putting your notes in on this one.
Well, I'm hoping we're getting close to having a finalization so that we can really
You are.
start finalizing
Right.
this paragraph by paragraph.
And then the other thing is, if you notice in the draft, there are boxes in the draft, and that's
Yes.
what I call it, and you guys have seen that before, that's the Chinese menu. That's where staff really doesn't have an opinion, or we may have an opinion, but we don't think we are allowed to have an opinion. So examples might be the ratio. What is the correct ratio? We want your number. It might be too little, it might be too much, I don't know. But that's, that's not our call. That's for you. You guys are paid the bigger bucks for that.
Yeah.
So
I'll
sorry.
note that on my return.
Yeah. Yeah. So, I mean, where you have that distance, where you have the ratio, I want your answers, because I dare not figure that one out.
Okay, go ahead.
Audrey, on the last 2 pages that you have, or the last page, where you have removed things and stated the reason why, the statement that you have there, for example, is the final result.
Right. It explains why things were taken out, because I felt that citizens, I could hear them now. Not every citizen, of course, but different people ringing the air. Well, I'll give an example. Why don't you use E-Verify? Well, we're not allowed to use E-Verify.
Okay.
The Supreme Court also made it very clear to the state of Arizona what you're allowed to do and what you're not allowed to do when dealing with immigrants. Just because somebody might be a different skin color doesn't necessarily mean they should be profiled. There's some fun little stuff there. So yes, I mean, that section, and there would be things too. I don't have the list in front of me, so I didn't, I mean, there was a lot of them, again, the firearms. I had the language in there, and it makes common sense that you should not be allowed to bring a gun into a shelter. But I can't write an ordinance saying you can't bring a gun into the shelter.
I hear you.
It doesn't mean that we're allowing guns in a shelter. It's the opposite. We're requiring the state to do the state's job. And that's the hardest part for me, for local officials, for you guys, for the citizens. This is not the only thing that a shelter is going to be responsible for. The shelter is going to be responsible for the building code. They're going to be responsible for the fire code. They're going to be responsible for certain laws that they're going to have to follow. And that does not need to be repeated in the operational, because a lot of times when we repeat it, we're trying, similar to the setback and encroachments, we're trying to write something that we think is correct, but we end up being more lenient than we should be.
Okay, under, we were talking about the intake forms, because in all of our discussions, the submittal, the information that was submitted on the intake form was kind of the meat and potatoes of the whole deal as I read it. It was a very important thing, and one of the questions that came to my mind during that time was who was going to prepare this form, and so forth. So I see that under item 3, you have essentially gutted the intake form. Basically, it's going to be
I don't have the draft in front of me.
but essentially that's what it is, because a lot of it's public record and those things are illegal.
Oh, this is where,
And I
as far as
understand
reporting
that,
to us,
but
yeah.
yet, in our entire discussion here, the intake form was really the heart and matter of the information that we were going to get about this person. And now, there's literally very little information we're going to have about this person.
And do you really think people's right to privacy that I mean, if you can explain why we need to know that I had a bankruptcy, or I need to know, let's say I have inactive tuberculosis. Do I need that to be in a public document that's not protected?
I see your reason. I understand your reason. I have no argument with it. But the point I'm getting at is that of all of our discussions and our workshops and so forth, the information that we were gathering on the intake form was going to be the basis of how we were going to act with this operation. We considered it to be a very, very important part of the whole thing. And so if we're not allowed to do that by law, then we need to have some other.
Well, it doesn't mean that they don't have
Much out of
intake. The
this.
question is that what do we have a right to intake?
Okay.
I mean, some of it's philosophical. Where do you
But
want
if it's
government
against the
to
law, it's
intrude?
against the law. If
Yeah.
you're not allowed
I
to
understand that,
collect the
but-
data.
Yeah, I mean, when
The point
people
I'm
are
getting at
checking,
is that we have depended on that intake form to gather information about this person.
right, I don't have exactly what, I mean, because I can look at the earlier and I can look at what the intake was going to have in it. I am sure that the parts where I would take out, that I remember taking out, there was something where we required you to show not just your driver's license, but also your working papers and your passport and your birth certificate, and going, I don't have one, if I was homeless, I probably really wouldn't have those documents, but if you asked me today to produce all these documents, I don't know if I could produce them, especially if I'm needing emergency shelter. But 2, you're now giving somebody the ability to do some identity theft issues. I mean, there was a lot of pitfalls. So, I mean, again, I need to probably look at the ordinance to see what part I took out, because I think what we're talking about, the suggestion was requiring the person to show, similar to an I-9 requirement. The I-9, which is, that they have the right to work in the state.
Well, I remember part of our discussion was that we would have these intake forms with all this information, and when that person left, we could share that with somebody for a job application or whatsoever. It was going to be used for more than just identifying this person. I mean, as I visualized it, it was a very important.
Well, what we're still
Yeah.
doing is we're still looking at that, using that homeless database that would track different movements, and what we are allowed to collect, we are still requesting.
Okay.
Obviously, some of the medical information and some of the personal information we're not allowed to collect, so that has left. And I don't have it in front of me either, so I don't want to go through line by line. But what we're still able to do, we're doing. What we're not able to do, we really weren't able to do when it was suggested, so it really didn't matter.
Okay.
So,
That's what I mean. You can't do something that's illegal, and that's pretty well
Yes, sir.
defined.
Right, I mean, you don't
But-
want to have HIPAA discrimination, you don't want to have AIDS discrimination, any of the protected situations, you don't want to create a problem in accommodations where you're now violating ADA. You don't want a situation where you're violating, you're basically trying to keep the shelter, say you want it to be white, so you want to make sure there's 20 extra paperwork to make sure the person is documented, so that you don't have illegal aliens, whether.
But there's a way of writing this so that the intake information can be used, as you said, with other homeless shelters or the movement
Right.
Of people who need homeless shelters. Also, I think that when they're out encroaching on your privacy, that can be done.
And there is. If you look in the back there's some data collection that the shelter is responsible to do in their operation and management plan that include, like, say, zip code of where the person is going to. So you will have some demographics so that you're able to track the movement of people.
And I think also we have in there where in these quarterly meetings or whatever we have with the shelter owner that some of that documentation that is needed can be required.
Mm-hmm.
Yes, it just wouldn't have a name
Right.
associated with it.
Right, because that's what we're tracking is, do you have felons? Have you had felons? So forth and so on. But you're able to get that by requesting that information.
Right.
Which would be part of maybe a questionnaire that you have worked up for these occasions.
And I need to
Sam, one
remind-
of the things that bothers me about exactly what you're saying is that when we had these workshops, the expectation was
Right.
from the public that we were going to have these things available to us, and I think at the time, we should have raised the red flags.
I think I raised it at every meeting. I said, this has not gone through legal review. I'll let everyone say their piece, and then after it goes through legal review. And I think I said that at every one of your workshops.
Well, the workshops were a tool for gathering opinions and information.
Right.
But I think the workshops build up an expectation that
Well-
now is not going to be able to be produced.
Well, but some people during that workshop, quite frankly, said things that would have come into the final solution during World War II. And I am not going to allow the
I hear
city
you.
to do something in that effect. I will allow people to have their free speech. They're willing to say whatever poison or venom they wish to say. But if it is something that is clearly has a constitutional implication,
That's why you're there.
yeah. But I will allow everybody to say their piece, and I will, listen to it peacefully, and I take the information as it comes in.
Some of the people at the workshops made comments that made me believe that they thought that we were going to make the decision here and now about shelters.
Today?
No. In the past workshop, some comments were made that made me believe that.
Well, yes, and I think ultimately it's city council, but city council did tax you with those requirements. But again, when it comes time to drafting, I still need to make sure whatever the final. Now, it's no different than when you guys did the agricultural. You had probably some people's opinions that people might have thought chickens would not be allowed, chickens would be allowed. At the end of the day, you have to come up with the correct, what you guys think is correct.
I have another question, Audrey. When we finally transmit our findings and recommendations to City Council on the homeless shelter thing, do we have the ability to portray to Council the significant negative feelings that the public has presented to us about what they wanted?
I don't think that
I
would
don't
be
think you need to
necessary.
worry. Yeah, they'll come back.
But yes, you can. But I'm not exactly sure that's necessary. I think they probably have that.
And understand, when I'm saying this, I'm not saying that everybody made that statement. I think most of the people who came up here were pragmatic. They gave well-thought-out reasons. But I'll give an example. Somebody came up to me and suggested that people when they're in the shelter, they had to have identification. So while they were walking around in the city of Bonita Springs, you could identify them as a shelter resident. And it was a liberal person. It was not somebody who is a terrible person. The person is a good person. They just did not fully think out what they were saying, and the consequences of what they were saying. And does that mean the city would be about to do everything else that was terrible? No, of course not. But it does mean we need to be careful about certain things because people do have constitutional rights in this country, and we want to preserve those constitutional rights. And as a city actor, local government, I want to make sure city council stays within the confines, at least, and we're going to have problems anyway, because I'm not going to pick up everything. I mean, I will tell you now, I put in some language on panhandling in there, and I was looking at some slip opinions about the First Amendment rights for panhandling. And I got to tell you, until I read the slip opinion the other day, I didn't even think, panhandling has any rights for First Amendments. Hey, I'm sorry. We can regulate time, place, manner on panhandling, but we have to be careful that we don't go into the speech element of panhandling. So, I know, but there's cases protecting people, and,
Even washing windshields.
I will tell you, when I sent the draft to Ms. Grady, I did not, windshield is one, and that's in the Pottinger cases. I did not see some of these issues, and so that's why it's being sent to another lawyer. I mean, I picked up what I could find, but give me a break. Does panhandling seem like a First Amendment right issue? I mean, I think most people would say no, but the courts say differently.
Anything else?
Let's go.
I make a motion that we close the meeting.
We can't do that yet.
Right.
Can't do that
Public
yet?
comment.
Public comments.
Public comment.
Oh,
Some
yes.
folks have been waiting here very patiently
3 hours.
all day.
Hi, I'm Dave Gallagher from Cedar Creek. I'd like to say that I have reviewed the latest operational ordinance, and I am impressed and very happy to see the changes that are in there. And many of our comments as citizens have survived and are there, which is very nice. And so I'd like to give an attagirl to Audrey here for all the fine work that she's done.
Very good.
We know that she will continue in the future. And I think that's all I wanted to say, that we appreciate all the hard work that's going into it. Thank
Thank
you.
you.
Yeah, we realize that too.
Thank you.
Like I said, I'm going to be redundant. I'm Pat Zimmerman, Cedar Creek, Be Safe, Bonita. And I, too, would like to thank the LPA and City Attorney Audrey Vance, John Dahmer, and all their support staff as well for all their hard work in writing the ordinance for the homeless shelter. And I also would like to thank my fellow workshop friends as well for all their diligence and input as well. And at the next meeting, I'll speak in the areas that I would like to see changed. But great job.
Thank you.
That's nice.
Hi, Linda Schwartz from Cedar Creek. I'll echo those sentiments. I'd like to thank the LPA for all of your hard work, City Manager Carl Schwing, the Community Development Department, and consultant Alexis Crespo, as well as Audrey Vance, for listening to Bonita residents' concerns about zoning and shelters and incorporating those suggestions and concerns into draft ordinances. The drafts reflect much of our concerns and input, and for that we really appreciate your attention to these matters. Thank you.
Thank you.
Thank you.
I didn't expect everybody to be so nice, and here I am going to be nice. I wanted to talk a little bit about the history. Rex and I served on the Bonita Springs Incorporation Committee, and we were part of a successful team in becoming the city. And we stuck with government light. There's a couple little changes in the charter, like term limits, that I'm unhappy with, but it's not significant. Bonita Springs and its government light is the envy of many cities across the nation. They hear about us. In fact, I recently, didn't Carl get us involved and we got some kind of an award? The next thing I want to say is, with these operating ordinances and all the things we have put you through, myself included, you as the LPA, these operating ordinance on homeless shelters and the one that's coming up on social services in general will put us on the map. There are 5 cities I'm in contact with that are dying to see the finalized versions. They wish to follow us. We don't have to follow the old rule of school. When you get just so big, you have to have this. We are doing something unique, and we are making sure we're maintaining a quality of life. And I want to thank everybody. And it was fun to be part of the referendum and win, and this is going to be a big win for us and make us a shining star in the whole nation. Thank you.
Thank you.
Thank you. Anyone else? Thank you all for your comments. Our next item is the next meeting, which will be is set for Thursday, December 13th at 8:30 a.m. That works for everybody that's here? Okay. Should be back. I don't have any long-term trips planned. Approval of the minutes. Everybody had a chance to,
I move they be approved as read.
I second.
that.
Third.
motion in 3 seconds.
That's pretty good.
Anyone opposed?
Motion in 3
So moved.
I'm jealous of Debbie because you guys review that real quick and then.
And we stand adjourned at 12:13. Thank you.